Good evening, Madam President. Madam President, I struggled all day with whether or not I wanted to speak this evening because after so many hours, all of the arguments that are worth making on both sides have already been made by people who are much more eloquent than I. But then I heard one of our colleagues a couple of hours ago mention that this was possibly her last time in the circle, could be for some of us, and I thought to myself, boy, I really don't want to miss this opportunity to stand here in this chamber and let it be known that Senator Bizzarro supports our men and women in blue. Our police officers, our corrections officers, Capitol Police, all of our public safety personnel. I respect all that you do to keep our community safe. I support you, and I thank you for it. And I would suspect, Madam President, that all of my colleagues around the circle would say the very same thing. And yet, we're about to pass a bill this evening that I think does more to demoralize our police officers than it does to hold rogue police officers accountable to the public. I will tell you that when I learned we were coming into special session to vote on a police accountability bill, without even knowing what the content of that bill was going to look like, I already felt conflicted. And I'll tell you why. So, I'm a supporter of our police, our law enforcement personnel, and thankfully I have not had some of the awful experiences that we've heard about this evening in this circle. But I'll give you a different perspective. I've had the opportunity over the years to represent a municipality, the city of New Britain. And I've been the city's corporation counsel for many years. First few years in that role, I was tasked with defending police officers in cases where I thought their conduct was pretty egregious. They weren't excessive force cases, not all of them, but I could tell that we had some bad apples in the bunch. And I thought to myself, this just isn't fair. There's something about the system which isn't right. It should be a lot easier for the city to terminate them. We shouldn't, as a city, as a municipality, bear the cost of paying for legal defense for these bad actors. The taxpayers of the city of New Britain shouldn't bear that cost, because that's what ultimately happens. So I said to myself, boy, I'm going to be in a tough spot with this vote. And I may be inclined to support it. So I imagined that when I saw the bill, it was going to go a long way toward addressing those very things. But with all due respect to the very distinguished co-chairs and ranking members of the Judiciary Committee who I know worked incredibly hard on this bill, I don't think that the bill does what it intends to do. Again, it's a police accountability bill, at least in title only, that does nothing, absolutely nothing, to hold rogue police officers accountable to anybody. What it does is perpetuate this stigma and false narrative that police departments need to be defunded somehow. And what it does is it burdens municipalities because it makes them spend money that I think would be better invested in recruiting, training, and retaining good police officers. So it's late. I don't want to spend too much time just rehashing some of the points that were already made, but I just want to echo some of the comments made by some of my colleagues earlier about various sections of the bill. I've gone through it. Sections 21 and 22, I think, are very problematic because when we're talking about stripping the ability to have officers do a search that's consented to, I think what we're doing is we're removing a very effective tool of de-escalation in that police officer's arsenal. Now, I've heard from police officers who tell me routinely that that is a very effective way to de-escalate a situation. And what we're doing is we are now immediately placing that individual in an adversarial posture vis-a-vis that police officer that stopped them. I also have serious concerns about the sections regarding penalties for an officer's failure to intervene for all of the reasons that were stated earlier. In particular, with respect to Section 43, I'm not sure how in practice that would work with the Department of Corrections. I heard the distinguished chairman give an explanation earlier, but I'm still not convinced, with all due respect. I think it's very problematic in that setting in particular. And Madam President, if I may, just a couple of very brief questions to the distinguished chairman of the Judiciary Committee.
Please proceed, sir. Senator Winfield, prepare yourself.
Thank you. Senator, with respect to Section 16, which is the section that pertains to the behavioral health screening, I just have a couple questions. I looked through it, and I'm wondering, is there something in this bill that provides for what happens if an officer were to fail the behavioral health screening? Perhaps I missed it. I apologize if that's the case. Through you, Madam President.
Senator Winfield.
Madam President, if you would give me a moment to get to the section, I will be happy to respond to the question. Madam President, sorry. I know that, and I'm a little sorry, it's been a long debate. I know that there's a part of the bill where we talk about coming up with the policy around this. Sorry. Can you give me a moment? Thank you, Madam President. I'm sorry, it's in a different section. That's why it took me a moment. So if you go to line 126 through 147, that's where it talks about post and its responsibilities, and it talks about developing and implementing written policies in conjunction with the Commissioner of Emergency Services and Public Protection around this issue. So the manner in which we operate will be promulgated through that process, through you, Madam President.
Thank you, Senator Winfield. Senator Bizzarro.
Thank you, Madam President. I thank the chairman for pointing me in that direction there, because I do have significant concerns, and I suppose that the bill would anticipate that the regulations will be fleshed out in the future. But it is a difficult question indeed, in my opinion. You know, do we rehabilitate an officer who fails a behavioral health assessment? Does that officer get assigned to desk duty? Is the officer offered some sort of early retirement incentive? What about the officer's pension? Does that come into play? Is there potential for abuse in the event that an officer has a behavioral health assessment coming due not too many years prior to a potential retirement? So I was very concerned about that section, and hopefully those items are fleshed out in sufficient detail to assuage any of those concerns. I do have a question also, Madam President, through you, if I may, regarding Section 17.
Senator Bizzarro, please proceed.
Thank you, Madam President. There has been, Section 17 deals with the, let me just get to that section here, I apologize. Deals with the Civilian Police Review Board. And there's a provision, and that's lines 803 through 814, Mr. Chairman. I'm wondering, there is a provision in here which permits the office, the Inspector General, which is an officer to be created by this bill, permits that Inspector General to essentially put a moratorium on any review by one of these boards pending the investigation by that Inspector General. There has been some discussion in recent days regarding the constitutionality of the provision that creates the Inspector General. And I know that the distinguished minority leader, the Senate minority leader, did ask for an opinion from our Attorney General as to the constitutionality of that office being created in this bill. As a side note, I find it ironic that our Attorney General says that it's an issue that's too complex to offer an opinion in such a short amount of time, yet we're expected to vote on it today. But I digress. So my question through you, Madam President, is what happens in the event that it is determined by a court that the Inspector General that's created by this bill, that section fails constitutional muster? What happens in that scenario?
Senator Winfield.
Thank you, Madam President. I would imagine in that scenario there wouldn't be an office of the Inspector General, and therefore there would never be the opportunity for the Inspector General to stay the investigation of the Civilian Review Board through you, Madam President.
Senator Bizzarro.
Thank you, Madam President. That's what I assumed the answer would be. I find that highly problematic because right now, my understanding is what happens in these cases is that the state's attorney that's investigating these cases does communicate with, for example, with internal affairs or a municipality because there are serious concerns about expoliation of evidence or interfering with the state's attorney's investigation, witnesses, and the like. So I think that this section ought to, at the very least, contemplate a scenario where there is no Inspector General and should confer upon the state's attorney the same right. So I'm concerned about that. That's all I have for questions through you, Madam President, to the chair. And I thank the good chairman for not only for answering my questions this evening and for his work on this bill, but also for standing here for so long, answering all of these questions from everybody. Just a couple of other comments, Madam President, before I wrap up. I have read through Section 41 of this bill, which has been the subject of so much debate tonight. And I've read it over and over again. I'm not sure, quite frankly, what to make of it. I don't know what it adds to the current law. My perspective is that what it does is essentially substitutes one legal doctrine, which is objectively good faith belief, for another legal doctrine, which is qualified immunity. So that's the legal answer. As a lawyer, I could tell you, yeah, that's what it does. You swap out one standard for another. That's the legal answer. What does it mean in the real world? What does it actually mean? Well, I could tell you what I think the proponents of the bill want it to mean, and that is that it offers expanded relief for plaintiffs, that it enhances the punishments in the form of monetary judgments against police officers who are found to violate somebody's civil rights. That's probably what the proponents want it to mean. I think what it actually means in practice, and I always tell my clients all the time when they come in to see me, I ask them all the time, do you want the legal answer or do you want the real world answer? So there's a difference. And in practice, what I think this means is that you're going to see more low-level settlements paid for by municipalities and and ultimately the taxpayers. Now, why do I say that? Well, municipalities, as the exchange between the senators just a moment ago highlighted, municipalities are obligated to pay for attorney's fees for police officers who are sued. In my capacity as corporation counsel for the city of New Britain, I have had years where almost the entirety of my outside counsel budget has been spent paying for legal fees in defense of police officers, because Connecticut law says that municipalities have to indemnify police officers, and it costs a lot of money. And despite what some people believe, I can tell you, based on personal experience, lawsuits are brought against police officers every single day. Every single day in the state of Connecticut. So the idea that qualified immunity acts as a barrier to lawsuits, that's just incorrect. So what's going to happen here? Well, I think what's going to happen here is you're going to have state court judges now who have to start building a framework, a body of law from scratch. And that's because we have this new standard, which is the objective good faith belief. So we're going to swap out qualified immunity, and now it's up to a state judge to determine whether an officer had objective good faith belief. So here's what it means for you non-lawyers. There is a tool that attorneys use to get a case adjudicated on the papers prior to trial. There are a few different mechanisms by which you can accomplish that. One of them, and it's been mentioned on the floor here this evening, is called summary judgment. What that means is that you've gotten enough discovery in a case, you've taken depositions, and you've gone through the facts in sufficient detail, which would allow a reasonable trier of fact, or a judge, who's reviewing all the facts to determine whether legally there's any grounds to proceed to a jury with a claim. Now that's simplifying it for purposes of this discussion, but that's essentially what it does. So we're going to have a scenario here where judges, state court judges, are starting from scratch. That means they are going to be reluctant to grant summary judgment, just as the federal courts took 40, 50 years to develop this body of case law about what is or isn't a clearly established right. So too will the state court judges need time to flesh all of this out. So they're going to be inclined to say, you know what, we're not sure. This is the first time it's come here in state court. Yeah, we've got some federal decisions that we could look at as a guide, but it's not absolute. And I'm not taking this out of the hands of a jury. A reasonable jury might disagree with me and might say, you know what, the officer did not have objective good faith belief, and therefore I'm letting it proceed. So you, Mr. Officer, you municipality that's paying for the legal fees, your motion for summary judgment is denied. Go talk to the jury and let's see what they say. You know what happens in that scenario? I'm going to tell you what happens in that scenario. Most of those cases are going to settle. And you may be thinking, ha, that's good. That's a good thing for our plaintiffs. No, it's not. Why? Because you've got the worst case scenario now. You have a situation where you've gotten past summary judgment and you could potentially go to trial, but as we've been talking about for the past few hours, guess what? This bill does not remove some minimum threshold level of protection for the police officers. The plaintiff still has to overcome that burden. Yeah, it's not qualified immunity, but as the good chairman pointed out earlier, there's still a minimum threshold which is going to act as an impediment to frivolous lawsuits. And so just because the judge may be inclined to let a jury decide it, that doesn't mean that a jury is going to decide in the plaintiff's favor. So now you're going to have a plaintiff's lawyer who's more inclined, because it's ambiguous, it's nebulous, to take an offer from a municipality or a police officer to settle the case prior to trial. what happens? Well, you're going to be left with a situation where you've got lawsuits that have very little merit that are going to be settled at levels that are not going to satisfy plaintiffs. Plaintiffs who feel like they've been victimized, like they've had their civil rights violated. They're going to feel wholly unsatisfied. They're going to be unhappy. They're going to be even more distrustful of police departments and the court system. Speaking of the court system, you're going to have a court system that's already taxed be overwhelmed even more, looking for more resources from us. You have plaintiffs' lawyers who will be very thrilled with this. And you're going to have municipalities, and by extension, their taxpayers, left holding the bag once again. And I understand, I heard the good chairman mention earlier that, hey, you know, if the price to pay for stopping some of these problems that we have in our society is an increased cost to municipality, hey, somebody has to pay. And I get that. I don't discount that argument at all. But what's the goal here? I mean, I would think that the goal is to adequately compensate individuals who've legitimately had their civil rights trampled. Because if that's the goal, then this doesn't accomplish it. If the goal, however, is to turn every single police interaction into a slip and fall case, well, we're well on our way to doing that. And at the end of the day, very simply, I'm going to vote no on this bill because for me, the bill does not pass my balancing test. And that balancing test is, do the very few positive components of this bill, because there are some positives in this bill, outweigh the substantial harm to our citizens and our communities that will inevitably result when cities across the state are unable to find and retain good police officers? The answer for me is no, and therefore the vote for me must also be no. Thank you, Madam President.
Thank you, Senator. Will you remark further on the